Okay, good morning.
Morning.
Let me go ahead and introduce the other members of the panel. We have Judge Wallace and Judge Sasso. We're here on the case of Raber versus State Farm. This oral argument is being live streamed so that members of the public can watch. And with that, how much time does appellant wish to reserve for rebuttal?
3 minutes if I could.
Okay, and you can see the clock there, but I'll try to help you in that regard as well.
Okay.
Okay, you may proceed.
Okay, thank you. Good morning. May it please the court. Matthew Struble on behalf of the appellant this morning. And this is a case, it's a property damage claim where State Farm immediately denied the claim with the sole basis of their denial being that they didn't believe the damage to the roof was caused by hail. In their denial letter issued less than 60 days after receiving the claim, they cited an inspection that they performed and alleged that the damage to the roof that they observed was caused by wear and tear and not by hail strikes. That was the sole basis of their denial. And in this case, the trial court committed legal error by not finding that they waived any forfeiture defense. And Florida law is clear that when an insurance company asserts a denial on a basis other than policy conditions, once it does that, that is tantamount to a waiver of policy conditions.
Well, let me ask you about that. The Supreme Court has addressed this in a couple cases, and they use the language that if that denial occurs during the period for presentation of proofs. Didn't this letter from State Farm come after the time period had expired for both proof of loss and giving notice?
No, if you look in terms of the notice provision, obviously there's been a number of cases on that. Cases have said that 4 years after the claim could be factual issue, whether that's late or not. There's no specific time provision in the policy.
Right, but that's a separate issue. I'm talking about your statement that it's automatically waiver if they don't put it in the original denial. And of course, the rationale for that rule is based on the fact that people aren't called upon to do, futile acts. So if the insurance companies are denied coverage, then why should you be required to do a proof of loss or notice, further notice or whatever? But, that's the language that is in the Florida Supreme Court case of mutual beneficial health. And that's the one that's followed by the Supreme Court later in Kiel and by other courts is, that's the reason for the rule. So assuming that the notice time had lapsed or the proof of loss time had lapsed, I'm having difficulty seeing why there'd be a waiver. Now, I understand you have a different argument that no reasonable notice was given, but.
So in terms of that, there's the policy requires prompt or immediate notice. And there's case law that says, hey, a bunch of factual was resolved that 4 years has been sound sufficient. In this case, it was a year later. And our separate argument is there was a number of reasons for that. But the purpose of the provision is that they received that notice. They never took the position that it was late. They never claimed there was issue with the notice. And you can see the reason why the Supreme Court, going back many, many years, has found that's a waiver is because it's a forfeiture provision. So if the insurance company is contending that somehow the notice is late, then it should assert that. And reasons for it are, some of them are obvious, such that if it thinks the notice is late, then you should assert that so the insured has an opportunity to say, oh, okay, you think the notice is late. What can I do to help you in your investigation of your claim? I can get you witnesses, I can get you documents, and then that issue can be addressed. But in this case, State Farm never took issue with the notice at all. It received the notice a year later. We give some of the reasons why the notice was a year later, and never took any issue with that at all. And very similar to that is the proof of loss provision. It is common for proof of loss to be required within 60 days, typically after an insurance company requests it. In this case, State Farm denied the claim 40 days after receiving notice of the claim. They never requested a proof of loss, and you could see, the Supreme Court in all these cases say that policy conditions are futile when the insurer denies the claim, and that, this case is the best example of that. Their position is that it's not covered because these markings you're showing us are wear and tear, not hail, then things about technicalities in terms of a proof of loss and the exact amount of the claim are futile because their position is that the claim is not covered. And that's exactly what their position was in this case. So this case is directly on point with the logic of all the cases that have been adopted by many other circuits.
In State Farm's denial letter, they state the company does not intend by this letter to waive any policy defenses in addition to those stated above, but specifically reserves its right to assert such additional policy defenses at any time. Do you think that language has any meaning, or?
First, I would say it has no meaning. I mean, conditions are something that have to be specifically raised, and that's clear from the decision on the claim through defenses. Potentially as to exclusions, and case law have indeed said that you cannot waive policy exclusion. The reason being that you cannot create coverage that does not otherwise exist. And they have an argument that allowed them to assert additional policy exclusions, and we never challenged them as to that. If you look at their fences, they had 5 policy exclusions and 1 condition. It is not sufficient as to conditions because conditions are forfeiture provisions which have to be raised. They didn't raise it in any manner. There's no reference into any allegation at all that they believe there was any issues with policy conditions whatsoever. So at best, that allows them to argue other exclusions, but it doesn't allow them to thereafter raise conditions which were never raised in the first place. And that's what every case, when you look at conditions as waiver of them, stands for. And that's directly on point on this case.
What is your best case in that regard that you think controls this case?
There are a number of them, but I would say, going back to the Supreme Court about 50 years ago, the Keel versus Independent Life case, which held when the denial was on grounds other than failure to furnish notice or a proof of loss, that's a waiver.
That's going back to Judge Evander's point on the justification for that case was compelling somebody to engage in a futile act. And you mentioned the denial is 40 days after receiving the claim. And just to clarify, that 40 days is not from when the loss occurred, but when the claim was filed, correct?
That's correct. And, there's State Farm does have an odd provision as no one ever has, found that to be proper or make any sense. Obviously it doesn't. You have to ask for a proof of loss. I never even asked one for this one in this case. And obviously
there's no language in this insurance contract though that State Farm must request a proof of loss, right?
Right. So obviously if they actually believed that an issue and didn't waive it, they could have denied the claim right out of the gate saying, hey, you should have submitted a proof of loss. We just received notice, 60 days has passed. They never did that. And obviously the importance of it is if you get to that, then you get to prejudice. And that's why they're required to actually assert it. So when they received the claim, State Farm was required to say, hey, we didn't receive a proof of loss. We think you breached that provision. Now, obviously the reason for it is then the insurer could say, okay, what is the issue here? How do you believe you're prejudiced? What can I do to help you? Here are estimates. Here is a proof of loss. It's a 2-step process, and first is waiver, so we don't even think you get to the prejudice. That's exactly the reason for it. If State Farm believed that the proof of loss had to be submitted within 60 days, otherwise there could be a forfeiture of policy that coverage that otherwise exists, then they're required to assert it. And that's what all the cases stand for. And they've never
Let me ask you this, since you talked about prejudice, would you agree this is a condition proceeding we're dealing with, or two conditions proceeding we're dealing with?
Courts have defined them as conditions precedent. But
Okay, the conditions precedent, is there a presumption of prejudice?
Yeah, but I think there is. But I think it's what this really
So if there's a presumption of prejudice, why does it need to be expressly pled, since the burden's going to be on the plaintiff to overcome that presumption?
Because the question doesn't turn on whether it's a condition precedent or a condition subsequent. It turns on whether it's a forfeiture provision. And if you look at the Quran versus State Farm, where they said, hey, EUO or a CME, if the insurance company, State Farm in that case, has to plead and prove prejudice. And that turned on whether it was a forfeiture provision or not. And in this case, undeniably, both provisions, the proof of loss and the notice provision are forfeiture provisions. And that is the only distinction that matters, because the only time there can't be a waiver is when you would be creating coverage that otherwise doesn't exist, meaning that you can't waive a policy exclusion, but you can waive a forfeiture provision. And undeniably, that's exactly what both of these provisions are. And that's why we've outlined a number of cases that have found both proof of loss and notice as well are waived when not asserted by the insurance company. And that's
But Mr.
exactly-
Struble, aren't those cases are unlike ours factually, where the policy in this case requires the proof of loss and does not suggest or in any way outline that State Farm is required to request a proof of loss. Isn't that the factual distinction between those cases?
I don't think, if you look at the majority of the cases we cite to are involving State Farm themselves and issues with proof of loss and issues with late notice. And all the cases say the issue is whether or not the insurance company raises it and whether the insurance company denies it on the basis of saying that there's no coverage for the claim.
But aren't the facts of those cases different than ours? The policy language is different than ours. I believe there is a distinction there. Is that correct?
I don't believe so, because the only turning point is what their basis of the denial was. And if the basis of the denial is saying there's an exclusion that applies, then they waive any policy conditions contained within the policy. In this case, State Farm's sole denial of the claim was saying that there's an exclusion that applies, so they thereby waive all of their policy conditions. And that's the only turning point. You look at what was the basis of the denial. Here, the sole basis of the denial was saying is wear and tear. We don't think those damages are caused by hail. And that is what you look at, and that is what determines whether it's waived or not. And in this case, that's exactly what happened. So with all the cases saying if they deny it on exclusion, conditions are waived, that's exactly what you have here.
Let me go back to something you said. I'm looking at the Bankers Insurance versus Macias or Macias, however you pronounce it, Florida Supreme Court case in 1985. And there they found that a condition precedent, which created a presumption of prejudice, was a failure to give notice and failure to provide proof of the claim.
Yeah, so as to our first issue, the difference there is that that insurance company actually raised those at issue. So if
I know, but I'm getting your second point about, you
Okay.
said the prejudice presumption doesn't apply when you're dealing with the proof of loss, but it seems like the Florida Supreme Court held differently in really the seminal case in this area.
Yeah, so, and that goes to our second argument, but the reason why we don't believe you get there is because prejudice applies if it's not waived. So yeah, if State Farm denied the claim saying, hey, we didn't get a proof of loss from you, we needed that, our claims have been prejudiced. If they had said that you didn't report it timely and because of that, we can't figure out what actually caused the damage, then they would have preserved that defense. Then you'd get to the first issue, then you would get to prejudice, which is almost always an issue of fact. But in our case, State Farm, unlike the insurer in Macy's, didn't assert those things whatsoever. In fact, they asserted the opposite. They said, we're on your roof. It was pretty easy for us to figure out that damage you're showing us isn't from hail. We don't think those coin-sized dents in the shingles are from hail. We think it's just normal wear and tear. So in Macy's, the insurer actually said, hey, we didn't get timely notice. We didn't receive a proof of loss. Our investigation has been prejudiced, and now we can't. We believe you breached that condition. None of that happened in our case, and that's why, as a matter of law, through their denial based solely on exclusion, they waived those things. So then when you get to Macy's, and the Macy's in the cases say, you consider prejudice, and that's generally an issue of fact, and you have to look at the reasons for the late notice. We have a lot of very strong arguments to that, but our brief makes clear you never get there because, unlike every other insurer these cases deal with, State Farm in their coverage decision letter never raised a condition whatsoever. And in fact, if you look at their investigation of the claim, according to them, they weren't prejudiced at all because within 30 days, they were able to very easily determine, according to them, that the damage that they saw is not from hail. And then that's what the case hinges on. And that's what the case, if you look at the denial letter from their affirmative defenses, the issue in the case has been whether the damage was caused by hail or not. We had a number of people and evidence showing that it was caused by hail. They've got one engineer that they argued said that it was not caused by hail. And that's the issue in the case, and that's in line with their own coverage decision letter. And that's in line with their own, within these cases that say if the issue is whether it's excluded or covered, that's the issue. And by them completely failing to say the notice was late and take issue with during their investigation or take issue with the proof of loss, as a matter of law, they waived those issues. So, you know, we think now being here on appeal, that aspect of it is solely a legal question. A legal question before this court is whether a denial based solely on exclusion is a waiver of policy conditions. And if you look at every case, it's in this case here lines up with that 100% on point, because the denial was solely based on the exclusion. They never raised any issue with timeliness at all, and they never raised any issue with the proof of loss at all. And that's how the case went on to ultimately be litigated. So as a matter of law, this court, based on the precedent, has to find that their denial based solely on exclusion was waived on the waived policy conditions. In this case, be remanded back to deal with the first 5 defenses that they raised, which actually deal with exclusions, because the 6th one about conditions was waived through the conduct we went through. So that because of that, we don't think you even need to get to the second aspect of our brief. But if you did and looked at that, I think that also requires this case to be remanded back, because there are a number of, you know, you look at, we set forth the reasons that it wasn't reported timely, and she set forth that out in detail, the plaintiff did in this case, as well as substantial arguments of why they weren't prejudiced. So we don't think you need to get to the second argument, but if you did, all those things that weren't considered by the court, you know, we think clearly are issues of fact that at a minimum would have to be sent there as well. So, you know, as a matter of law, you know, we think that the denial, undisputed denial solely on exclusion, as a matter of law, was a waiver, and that's really the only issue that needs to be reached at this point.
Thank you. All right, for the appellee.
Good morning, and may it please the court. My name is Ryan Jones, and I represent State Farm Florida Insurance Company. Your Honors, we're requesting this court to affirm the trial court's decision because the appellants did not comply with the conditions of the policy, and there is no evidence in the record that would rebut the presumption of prejudice that arises as a result of those failures to comply. I want to start by addressing the waiver argument that Mr. Struble addressed. And the only fact that is asserted to support the waiver argument is that the policy conditions were not cited in the denial letter. However, there is no statute or rule or case saying that a property insurer waives a policy defense simply because it's not cited in a denial letter. In fact, the law is exactly the opposite. We cited a number of cases in our brief that show just that. In fact, 2 of those cases specifically addressed a late notice defense that was not asserted in the denial letter, yet it was considered on appeal. And that's the Stevenson case from the 4th DCA and the Phelps case from the 1st DCA. So there is no automatic waiver as a matter of law simply for not including something in the denial letter. And the basis for that, Your Honors, is consistent with what Judge Evander's original question was about the compliance with the policy conditions and not being required to do a futile act. Because if we take that origin of the rule and apply it to this case, we look at the notice provision, for example. Notice can never be considered futile because if there's no notice, there's no claim. So it's consistent with the original rule. And perhaps even more importantly than that, it's also consistent with the general rule on waiver, which requires a voluntary relinquishment of a known right. And there's nothing in the record to indicate that State Farm voluntarily gave up its right to these defenses. To the contrary, as Your Honor pointed out, there is a specific statement in the denial letter itself that State Farm does not intend to waive any of its rights or defenses. So for that reason, there is not a waiver as a matter of law, and the facts don't show anything that suggests there was a voluntary waiver. And I think that—
Let me ask you this. You know, this came to us on summary judgment, not after trial. So whether the plaintiff acted reasonably in giving notice or whether you were prejudiced are typically fact issues. Would you agree? Typically fact issues. Would you agree with that?
They can be. That's correct, Your Honor.
Okay. So tell us how this record shows that it's not a fact issue that remains.
Certainly, Your Honor. So there's 2 issues that we have to address in that regard. The first is whether the notice was in fact late. And we cited a number of cases in our brief that state that notice can be determined to be late as a matter of law. And the common thread throughout all of those cases is that the insured was aware of damage and did not report it. And that's exactly what we have in this case. The alleged date of loss is May of 2016, but the claim wasn't reported until June of 2017. And what occurred in between those two dates is what's very, very important for both of these questions. In the case of notice, the most important fact is probably the repair that was conducted to the pool cage or the pool cage screens in October or November of 2016. The reason that's so significant is that the insured attributed that damage that they repaired to the alleged hail event in May of 2016. What that shows is an awareness of damage and a failure to report the claim when they were aware of the damage. In fact, they didn't report it for another 6 months afterwards. And that's the type of fact pattern that all of the cases that we cited in our brief demonstrate late notice as a matter of law. So that's how the trial judge correctly decided that the notice was untimely as a matter of law. But of course, that doesn't end the inquiry. Once that notice provision is breached, we move on to the second step of the analysis, which is where the presumption of prejudice arises and the burden shifts to the insured to disprove that prejudice. And again, there are examples of when that can be considered a fact question, but there's a series of cases that are directly relevant to this case, most of which are issued by the 4th DCA, that provide examples of when the prejudice has not been overcome as a matter of law. And for example, one of them is the Sleminski case. And the issue in Sleminski was that the contractors and the engineers couldn't distinguish between two different storms that could have caused the damage. And I submit, Your Honor, that's exactly what we have in this case. The primary witness that appellants are relying on is a gentleman named Mr. Hornacek. And his testimony, his report originally, he prepared a 2-page, quite conclusory report that stated the hail claim, the hail damage storm in 2016 was in fact the cause. But at his deposition, he stated that he could be wrong about that, and it could have been another storm. He also said that it could have been Hurricane Matthew, which occurred in the interim between when the May 2016 claim storm occurred and the claim was reported. So we have a number of different things that could have been the cause, and that's an example of how the prejudice cannot be overcome. Another example is outlined in the Kramer case. And in Kramer, the issue was that the experts couldn't determine between two potential causes. And we also have an example of that in this case. The potential causes that we're dealing with here are either a shingle, what they call a blister, or normal granule loss, as opposed to a hail mark, which also results in granule loss. And what's important in that, Your Honors, and I think this perfectly exemplifies why timely notice is important, because there are two different individuals that provided testimony about the distinction between blisters and hail marks. One is Mr. Hornacek, who actually stated that the two appear visually similar. There's small circular indentation or small circular marks where the granules have been removed for one reason or another. And he indicated that when you're determining between the two, it's important to look at all of the information, especially if, for example, a hailstorm came through 2 days beforehand. That would suggest that it was likely a hail mark. He also suggests you should look at soft metals or screens because those are other indications of things that will be damaged by hail. In this case, however, we don't have the opportunity to look at that because the hailstorm that's allegedly responsible for this was over a year before the claim was even reported. And the screens that supposedly were damaged as a result of hail and would show evidence of hail damage were repaired before the claim was ever reported. So
what's your response to the argument that because State Farm's expert was able to exclude hail as a cause of the damage, that there could not have been prejudice because State Farm was able to appropriately evaluate the damage?
Your Honor, that is an issue of causation. And basically what that comes down to is that State Farm's expert was able to give an opinion on causation. However, causation alone, according to the case law, is not enough to overcome the presumption of prejudice. And if we think about it, there are very obvious and logical reasons for that, because even though the expert was able to give an opinion on that, that opinion is subject to attack, for example, because the expert wasn't able to inspect until after a year later. And there are a number of things that influence that opinion, for example, the screens that were repaired are usually indicators of whether or not hail damage occurred, were not able to be inspected. So the opinion is weaker than it could have been. And I think the best case that addresses that is probably the Yacht Club on the Intercoastal decision issued by the 11th Circuit. It specifically states that a statement of causation is not enough to overcome the prejudice. And it outlines a number of things that show the prejudice that were not addressed in that case. And again, those apply directly to this case as well. For example, the 11th Circuit suggested that better conclusions could have been drawn without the delay. And we have that exact same issue in this case because we have all of the issues we've just talked about about distinguishing between blisters and hail marks. The next thing that
Mr. Jones, that merely goes to the weight. You're not in any way taking the position that you were unable, your expert was unable to reach the conclusion, but it just goes to the weight that arguably would have been presented to the jury, correct?
In that circumstance, yes, Your Honor, that's exactly right, because the prejudice is not simply a complete inability to make the decision. The prejudice issue that the courts address is whether the investigation was hampered. And that's exactly what the 11th Circuit talked about, the better conclusions. Another example, and this one I think directly addresses Your Honor's question, is whether the conclusions could have been drawn more easily than they were if the claim had been originally reported. And I'd submit that's exactly the case. That's supported not only by the case law, but especially by the testimony of Mr. Carpenter, who is one of the individuals that appellant would rely on to say that he could identify hail damage. But the problem with Mr. Carpenter's testimony is that he also identified a number of different things that could have caused the condition of the roof. And he also pointed out a trouble with distinguishing between the blisters and the hail marks. And his testimony, I think, is very, very instructive in this regard, because he states that both the blisters and the hail marks manifest themselves as a loss of granule. So it's the same end result. And when distinguishing between the two, he actually testified that if you have regular granule loss, or from blisters, you'll have slow granule loss over time. And you'll see the granules slowly come off the roof, and you may see indications of them in the gutters or on the driveway at the end of the downspout. Now, on the other side of the coin, with hail damage, that results in a very rapid loss of granule. And again, this is according to Mr. Carpenter. So when the hail damage comes, the gutters will fill up with granules, and the granules will be very obvious at the end of the downspouts, on the driveway, or anywhere else that the rainwater would discharge. And that, I think, is the perfect example of the prejudice here, because all of those granules that would have been lost, assuming this was a hail claim, were washed away over the course of a year. State Farm and its engineer did not have the ability to look at that evidence to address Mr. Carpenter's concerns about distinguishing between blisters and hail marks. And that's an exact example of why these claims need to be timely reported. And again, those are the individuals that appellant is relying on. Those are not State Farm's experts. Those are the witnesses that appellant claims can overcome the prejudice. But with that testimony alone, that shows the prejudice cannot be overcome. And I'd like to emphasize just a couple more points that the Yacht Club on the Intercoastal case drew out that, again, state the prejudice and what the prejudice is and what needs to be provided to overcome that prejudice. Another example it gave is whether the repairs that were conducted between the date of the loss and the date of reporting complicated the evaluation. And I'd submit that that is exactly what we have in this case as well, because the repairs we're talking about are the repair to the screen. And every one of the witnesses who testified, Mr. Hornacek, Mr. Carpenter, the engineer's report prepared by State Farm, all identify damage to screens as an indicator of hail damage. And since we don't have the screens to look at, and we don't have any photos of the screens beforehand, we can't tell whether or not that supports an indication that this was hail damage. And that's exactly what I'd submit the 11th Circuit had in mind when it was talking about the repairs complicating the evaluation. And another point that the Yacht Club on the Intercoastal case pointed out was whether the property was in the same condition as it was at the time of the loss. And here again, we have absolutely no question that it was not in the same condition. We know at a minimum that the screens were repaired and that 1 year had passed. And I think it's not only that passage of time, but it's what happened during that time, as I mentioned beforehand. In this case, we have the hail claim that supposedly occurred in May of 2016. But in the interim there, we also have Hurricane Matthew. And all of the witnesses have conceded that Hurricane Matthew most certainly could cause damage to the roof, could cause granule loss, and could have been an alternate cause of this. And that's the type of thing that prejudices an insurance company's investigation, because it can't distinguish between those two events. And so for that reason, Your Honors, we think that this case is very, very similar to the Slominski case, the Kramer case, and a series of others issued by the 4th DCA that show there is no ability to overcome that prejudice as a matter of law. And unless the court has any further questions, we'll rest on our brief.
All right, thank you. Rebuttal.
Just what's most telling is what State Farm doesn't have. And what State Farm doesn't have is a single case saying that refuting the fact that an insurance company's denial based on an exclusion waives policy conditions. All they did was they quickly cited the 2 cases in their brief and just mentioned them. And the first one is the Aetna versus Deluxe case. Aetna versus Deluxe Systems. If you look at that case, you'll see it didn't involve a policy condition at all. It involved another exclusion. And that's in line with every case I've said, which is that policy exclusions can't be waived, but policy conditions can. And every single case has said that. The only other case they cited to in passing was Stevenson versus Federal Insurance. If you look at that, you'll see it doesn't actually address their denial letter at all, as they indicated. But what it does address is the fact that in that case, the claim was reported 3 years later. It was reported 3 years after termite damage was discovered, after all the repairs were completed. And in that case, when you look at it, the issue of prejudice went to a jury. So the only case they don't have a single case that shows that they didn't waive policy conditions. The other case they have is when it was claimed was reported 3 years later, all the repairs were done, and issue of prejudice went to the jury. In our case,
could you address what evidence you think is in the record that creates a disputed issue of material fact as to whether State Farm was prejudiced, or whether the presumption in favor of State Farm or prejudice was rebutted as to the extent of the damage, not the cause of the damage?
Yeah, so if you look at, we filed a lot of evidence, but one of them is an affidavit of Kyle Pick in the record. He goes through his inspection. He goes through the photographs he took, the photographs State Farm took. He highlights them. He shows the dents in the roof. Says their position is that it's caused by wear and tear, which I think is completely wrong. My position that these dents in the roof are caused by hail. You look at the weather reports retained from their own expert. The only hailstorm to occur in that neighborhood was the one that's the date of loss. That's why all the neighbors in that area had insurance claims for hail, and all the other neighbors got paid for their hail claims except for this claim with State Farm. They can't possibly be prejudiced when they inspected the roof, they inspected the damage, and their position is that these photographs that we took and you're showing us, we don't think this is caused by hail. We think this is caused by wear and tear. And their report, their denial unequivocally said with 100% confidence that it was excluded. So within about 30 days, they got the claim, they did 2 inspections, they said, yeah, we see the damage, but this damage is caused by wear and tear. And that was their position. They were very quickly able to determine that. And if you look through the litigation, it's very telling, because the whole case, they cited 5 policy exclusions, and all the evidence come in showing quite clearly that it's hail. Everybody in the neighborhood had it from the same hailstorm. We've got 5 independent.
Let me ask you about that. Does the record reflect that your client was aware that all the other neighbors got new roofs because of the hail damage?
So they all became aware of it around the same time. So they had that May hailstorm. They didn't get on the roofs and inspect it. They all became aware of it a year later, and all the claims were submitted at the same time, and all but hers were paid, and roofs were all replaced on the same time. And that's a reason why it goes to the explanation, another factual issue. The reason she didn't report is because she didn't get on her roof after the storm. Well, as soon as she became aware of it, like everybody else in her neighborhood, she advised State Farm of it, and State Farm never took a position with the latents.
Okay, well, thank you. Your time is up. Thank you both. We'll be in recess till 10 o'clock.